Welcome to the concluding lecture on the second module of our course on Indian copyright regime, law and practice. In the last three lectures, we considered different case studies. One are the changes brought about by the US enactment of the Digital Millennium Copyright Act, where the owners of the proprietary material started relying more on electrical and technological means to prevent unauthorized multiplication or transmission. That is the Napster case. And we saw another case from Bollywood, namely the case of the Gulshan Kumar. It was actually a murder case, but there were also copyright ramifications behind the murder. Now let us look at a plain and simple copyright infringement case that involves the rights of the music directors, composers, in relation to producers, and the rights of the Performers' Rights Society, who in turn derived their rights from artists who were part of the production. Like here, the evolution of the movie industry in India played a very, very important role. I told you in olden days, there were big production houses, there was a financier, there was a director, and there were actors, there were music composers, lyrics writers, artists who play the music, and it was a big teamwork. We all know that. Usually, the movie contracts in olden days were excessively in favor of the production houses. After all, most of the entrants to the movie industry are yet to prove themselves actually. Okay. After they prove themselves, after about 5 or 6 or 10 years in the industry, they may be able to dictate their terms of engagement. During initial stages, all artists encounter a simple situation. Namely, they get sign it or leave it contract. You understand? If you are going to negotiate too hard on the terms of the contract, you are not going to get an opportunity to be part of the film. So, the lower your level in the hierarchy of the movie industry, the ability of an artist to negotiate a good contract virtually is non-existent. In a way, the movie production houses enjoyed what is known as a dominant marketing position. And all movies come in the category of a commissioned work. Commissioned work means the owner commissions several people to perform several roles for them to finally arrive at an artistic work, namely the cinematographic film. A cinematographic film is an artistic work and it is entitled for a contract and it is entitled for a 50-year protection, and beginning from the first day of January of the year in the next year after which it was produced actually. All right. Now, the very interesting case is, actually in olden days, there was also an important intermediary in the movie business. Movies are produced by production houses. There are artists. And thereafter, there is something called the distributors. And thereafter, you have theatre exhibitors. These are the different cogs in the overall wheel of the movie distribution industry actually. Each one is a powerful lobby actually, and in fact, the entire entertainment industry is full of dominant marketing position abuse contracts, and I will not go into it actually. But over a period of time, the artists started reserving different types of wages. For example, a music director like Illayraja. Okay. Now, Illayraja made his entry in the movie industry somewhere during early 70s or late 70s. He had a very long run, and many of his people from his family also, he got into the line, and his children are also composers. His brother is a composer, and he is a phenomenon by himself actually. And he didn't have any great forefathers to emulate in the industry. He is a self-made man. Now what in the earlier days the producers used to do is, the movies will be produced within a budget of about 15 to 20 lakh, and the composer of the music will be given about a lakh of rupee, and when he gets that lakh of rupee, the movie composer assigns all the rights to the production house. And thereafter, the production house will sell the movie rights, soundtrack you had called as, to someone, music rights to a recording company, gramophone recording company, and different rights to different people, different territories were separately negotiated. Now, in one of the cases, Justice Krishna Iyer said that the artists who perform in a musical work, they are also entitled for performers' right. The movie producers pay the artists for their work to be part of the movie. And if the music protected in the work is played beyond the movie, outside the movie, in orchestras, in functions, in halls, in nightclubs, then the production house does not necessarily have the rights unless the contract specifically reserves that right also. Now, this is actually a matter of negotiation between the music producer and the movie producer. If the music producer is new, okay, he will probably assign the rights to the producer in toto. And he will also assign the rights of the artist who played in that song. But when the music producer becomes big, he says, look here, you want me to set music for your movie. The movie is going to be for 120 to 180 minutes. I will give you the background music for the entire movie. You are going to have 5 or 6 songs. I will set a tune for the 5 or 6 songs. I will engage you, the required artist who will play it to my satisfaction. This you can use it as part of your movie as and when the movie is screened, or as and when the soundtrack of the movie is broadcast over a radio network. But the rights of cassettes, the rights of records, and now you want you to appreciate, now there is a whole new industry called the orchestra industry. Every town today has 3 or 4 orchestras. Big cities may have 10 or 15 orchestras. And many of these orchestras perform during wedding receptions. Okay. Now, most of the songs, Illayraja is an important person. He dominated the South Indian music industry for a period of about 3 full decades actually. He replaced Vishwanathan and Ramamurthy, the music duo, and for a very long time he was a unquestioned king of the South Indian movie music production industry actually. His brother is important, and he is undoubtedly a competent man. He got into tips with the lyrics writers, and he was hesitant to, but at the same time, if the movie banner indicates that Illayraja had sent the music, there was what I call as a brand value for Illayraja himself. So most of the movies subsequently, Illayraja reserved for himself the rights of the musical works that he created for different producers. This became a dispute. The producers were under a bona fide impression that once they pay the money to Mr. Illayraja for the purpose of setting music to their movie, they not only get the right to sell, the right to make records, phonographic records, video cassettes, audio cassettes, and get the money. So what they did is most of these rights they assigned to Performers' Rights Society. This you will find it in section 32 of the Act. It's a very long legislation. And section 32 says that this Performers' Rights Society is supposed to get a fair share to the artists. Okay. As in Calcutta High Court 2012 amendment to the Copyright Act, okay, performers were also granted certain rights. This was to last for a period of about 15 years. And each time the copyrighted music is played, the artist acknowledged in the production of the work will also get a pro rata payment. According to Illayraja, from the Performers' Rights Society, Bombay, for a relevant period he had to get something like 2.5 crores. But the Performers' Rights Society gave him something like 27 lakhs or something, and he had difficulties with them. Then he told all of them that henceforth, the Performers' Rights Society will not give any authorization to play any of his music. The tussle became so bad that in fact he threatened to sue S.P. Balasubramaniam, a very important playback singer, from singing his compositions in which S.P. Balasubramaniam himself had sung and performed as a performer. Anyway, the point is, recent judgment of the Madras High Court, given by Justice Anita Suman, and this is drawn extensively from the earlier judgment of the Supreme Court, Justice Krishna Iyer, who said performers have an independent right and that will have to be separately recognized, and as and when the performance is done outside the scope of a movie, then the performers also have a right to receive royalty. But the performers entered into a contract and gave this right to the Performers' Rights Society, which gave the authorization to various broadcasters and collected royalty. But there were some disputes on how the Performing Rights Societies distributed the proceeds, and this arrangement fell down. And now somebody like Illayraja says, look here, if you want to play my music, this music industry is a very big industry. There are orchestras, and the orchestras have individual performers. All of them come and perform Illayraja song, and Illayraja simply gave a ticket to all the orchestras and the performers, saying that if you want to perform my music, okay, for a reward, and he gave a lot of exempted categories. You want to use it in college, competitions, etc., no problem. You want to use my tunes in all the, what I call temple-related functions, no problem. But whenever you make money by going to halls and getting paid as an artist, okay, as a composer, I should get my due. And that now is 1/3 to the music composer, 1/3 to the lyrics, and 1/3 to the artist actually. Illayraja enters into a contract with each of the performer actually, and actually for a long time, it is the Performers' Rights Society took care of this subsequent broadcast and royalties for subsequent broadcast. Now, after Illayraja's precedent, if you are a big music producer, you reserve the right for yourself and you will have the retail to regulate the performance. And jurisprudence of compulsory licensing is yet to evolve in musical work, and we will discuss about fair use as a defense to a copyright infringement, which we will see in our later lectures. Thank you. I trust you enjoyed our discussion on the controversy between Illayraja and S.P. Balasubramaniam in the accompanying broadcast. Actually, the issue of performers' rights is becoming more and more prominent in developing societies. Recently, central government had given a circular that whenever copyrighted music is played on wedding receptions, social functions, where orchestra or recorded music is played during the occasions. And the Performers' Rights Society demanded royalties even for it. People thought that this is an abuse of their legitimate rights. And that is why Government of India had recently given a circular saying that this will not amount to infringement. But there are a lot of issues relating to copyright infringement, and these issues are complicated further by the advent of number 1, computers, number 2, information technology, number 3, developments in IT where all forms of data, whether it is moving pictures or motion stills or music notes, everything can be digitalized and transmitted. And these issues and more are considered in detail in our course on Indian copyright regime, law and practice. Herewith, we are giving you a link for enrollment at discounted rates. We would request you to try it, and thank you very much.